I'm ready, Chief Justice.
Okay, is this your first interview before
No,
the
it's not my
JSC?
first. It's not my first. I've been here before.
So you know the drill.
I think so, yes.
Okay, no, it will be fine. You have 4 law degrees.
Yes.
A BProc you obtained at the University of is it Teflo?
Limpopo, University of Limpopo.
University of Limpopo.
Yes.
All right. Then an LLB from Pretoria,
Yes.
University of Pretoria.
University of Pretoria, yes.
And then these 2 master's degrees.
Yes.
One in human rights and constitutional practice,
Yes.
and the other one in labor law.
In labor law, University of South Africa, yes.
The one in labor law from UNISA,
From UNISA, yes.
and the other one from the University of Pretoria.
University of Pretoria, yes.
And those, the last 2 degrees you obtained while you were working you were practicing as an attorney already.
Yes, I think one was an attorney, the other one was, I was an advocate already.
All right.
The other one was 2018.
You started out as a teacher,
Yeah, as a private teacher, that's where I started.
but just for a short while.
For 6 months. Yeah.
Why did you leave?
Sorry?
Why did you leave teaching?
Yeah, no, I wasn't a qualified teacher. Just there, I went to collect the result, and the principal asked me to assist, and I just stayed there for 6 months.
All right. Which subjects were you teaching in that 6 months?
I was teaching English.
All right. Then you joined the Department of Justice
Yes.
in Limpopo
In Limpopo.
as an administrative clerk.
Clerk, yes.
Clerking both in the civil and criminal courts.
Civil and criminal court. I was the
How
clerk
long
there.
were you in that position?
I started there from 1981, I think 1980 to 85 when I left to the university. Yes.
But then you became a prosecutor in that period.
It was an ad hoc basis. It wasn't like you were asked.
It was not a formal appointment.
Yes, for the appointment for a day. Yes.
But you did the work of a prosecutor.
Yes, I did.
All right.
Yeah.
Then you did your articles in 1989 and joined the Lawyers for Human Rights directly after you completed your articles.
Yes.
What did you do in that organization?
I was a director, a deputy director litigation, also coordinator for the program there. Yes, that's mainly what I did.
Then you started your own firm.
We were 3, yes, we started our own firm of 3.
With 2 others.
With 2 others, yes.
And how long did you remain in that practice?
We started, I think, 1993 or so, until I left 2006 and I joined the bar.
And you indicate that attorney's firm did all sorts of work across the board,
Yes.
civil and criminal.
Yes, we started like doing general things, and then, but mainly it was a criminal matter. It was a criminal firm, and then we did other things as well.
Then you joined the bar in 2008.
That's when I was admitted as a member, but I resigned as an attorney 2006. 2007 I did pupillage. In 2008 I joined. I completed my pupillage, and then I joined as a member of the bar, Pretoria Bar.
And you've been practicing as an advocate since?
Since then, yes.
Okay. What kind of practice are you running?
Well, I started as civil mostly, but mostly I also do labor, and also traditional leadership. That is what I do mostly.
Yeah. You also worked part-time as a CCMA commissioner?
Yes, I did a course there, passed, and then I was part-time commissioner at the CCMA, and even bargaining councils as well.
Okay, for about 6 years?
Yeah.
Okay. Just tell me about your acting stints in the High Court. When did those start, and for how long have you acted in the High Court?
Yeah, I started acting from 2019. Last year I had done 65 weeks. Yeah, and then I added 10, they said it must be 75 weeks, but I see I wrote 68 weeks. So I've been there. I also acted in Gauteng, but mostly in Limpopo.
All right. How many weeks did you do in Gauteng?
Gauteng, I think I did 1 or 2 terms in Gauteng.
Okay. And you've had occasion to write judgments during this acting stance.
Yes, I wrote judgments, yes.
In which areas of the law?
Different areas of the law. The last one that I did, I think I did on traditional leadership, but the last judgment that I see is attached here with the documents was about the traditional leadership court. Yeah.
Do you have any reported judgments?
No, I don't have a
Not
reported
yet.
one. Yes, there's only in Salfi, but I understand those are not reported judgments.
Okay. But you've sat in all the courts?
Yes, I said in all cases, criminal, civil, I did everything.
Have you conducted trials? Civil and
Conducted
criminal?
trial, conducted civil trial, conducted even criminal trials.
Okay. How many criminal?
Criminals that I remember now, I think there are 2 that I remember now. But I did.
To completion?
Yes, I completed them. I did them. One I did in Polokwane, the other one I did in Thohoyandou,
Okay.
the full trial.
Okay. Do you have any reserved judgments?
No, I don't have reserved judgment.
Any parted matters still
No.
requiring you to go back?
No, I don't have parted matter. I don't have reserved judgments.
All right. No, thank you, Advocate. JP Patudi? Oh, and I'm sorry, I forgot to welcome you. It's been a long 1.5 weeks.
No, thank you.
Welcome, JP. Do you have any questions for the candidate?
Yes, thank you, Chief Justice. Good morning, Advocate Ledwaba.
Good morning, Judge President.
Yes, the Honorable CJ has already inquired from you as to the number of weeks
Yeah,
for which you have acted as a judge
yeah,
in both Gauteng and Limpopo.
Limpopo, yeah.
Yes. I know that in your questionnaire you've initially mentioned 68,
Yeah,
but did you find occasion to act thereafter to increase the tally?
yes, yes, well, 68, yes. Even now, I'm on pro bono basis, but the last time I was also in pro bono, even now, I've been appointed on pro bono basis.
That's until the end of
The end
the
of
fourth term.
It's fourth term, yes.
All right. So all in all, you have, as we speak, about 75 weeks, as you say.
Yes, that's 75 weeks, yes.
All right.
Yeah.
In that period, were you able to sit and preside over agent motion court
Yes, I did agent court as
And-
well.
and also unopposed motions,
Also
opposed
on opposed
motions?
Yes, also on opposed motion, I did.
All right. What about criminal appeals?
I sat on criminal appeals as well.
Did you find time to write or opportunity to produce a judgment or
Yes.
judgments?
Yes, one of them is attached here to the documents. I also.
Yes,
write
in
a
your
judgment
questionnaire.
on it. Yes.
All right. And what about civil appeals matters?
Civil appeals as well. I sit on civil appeals.
Yeah.
Also the judgment, one of the judgment that I wrote here, I wrote for the full court.
Yes.
Yeah.
And I also see that you've mentioned in quite a number of judgments that you produced.
Yes.
And the question was whether was any one of them upset by the appeal court?
Yes,
And you
that's
mentioned only one out of those that you have mentioned.
Yes.
And there's a chair on top, there's one of, which was confirmed by, is it Medford?
Yeah, Mary Fawn
Yes.
was confirmed at the SCA and also at the Constitutional Court.
So, yeah, so it was confirmed by the constitutional, which means you were correct from the beginning
Yes. They
in
said
your
I'm
judgment.
correct. They said I'm
Acute.
correct. Yes, they said I'm correct.
Okay.
Yes.
Now, at page 21 of your questionnaire,
21.
2.1, I think it's under section 3 there, paragraph 2 thereof.
21. Yeah.
Have you arrived at that page?
Yes.
Yes. You mentioned that should you be appointed,
Yes.
you'd consider relinquishing your shareholding
Yes.
in both companies where you serve as shareholder
Yes.
and director, Gemini Holdings Pty Limited, and is that Chorwana
Yeah.
Properties,
Yes.
which is a close corporation.
Yes. Close cooperation. Yeah.
Yes. I note that you say that if I'm appointed to the bench, I propose to resign
Yeah. Well.
from those positions.
Yes.
But,
Okay.
yeah, the question is, what procedure would you follow to effect your resignations? I know many people tend to just issue letters and say, I've resigned from either directorships or from close corporations where they've got the members' interest.
Yes.
So what procedure would you follow in order to effect the necessary resignation within the ambit of company law?
No, I'll submit my resignation with the company registration office.
Yes,
Secret.
that's the registrar.
That's the registrar. We'll just
Okay,
say
so
I'm-
there's a form there. Yeah.
There's a
Are you
form that
aware?
you must-
The letter is not enough.
Yes.
Okay. Now, during your interview by this honorable commission in October of 2023,
Yeah.
an issue was raised about a dispute you have had with the Legal Practice Council.
Yes.
And I note that you say the issue has now been resolved
Yes.
by way of settlement.
Yes.
Would you confirm that?
Yes, I confirm that. I attach a letter from the complainant said we have resolved this, and then she undertook to withdraw a complaint, and later I was shown a letter that she sent to the council, LPC, to say, I'm withdrawing this. And later, and I was shown this letter in May, and then in June, I asked for a letter of good standing, then I was told there's nothing in my file.
Okay. Thank you. I have no further questions to the candidate.
Thank you, Judge President. Premier Ramatuba, can you hear me? Premier, are you on the line?
GNU.
Is she still connected? Yes, she is. I'm just going to check if they've the speaker. Okay. All right, we'll have to wait. You see, that's the problem. They want their names to be in these proceedings, but they don't have time for it. I just don't understand that. just don't understand it.
But she's the supervisor of the unit that processes these things.
Is she connected? Is that you, Premier? Good morning.
Am I Chief Justice?
Yes, although there's an echo.
I think the challenge is the connection on your side, because from the beginning, you've always been audible.
Oh, you were able to follow the proceedings.
I've been able to follow everything that you have been saying, and also what Judge President has indicated. What I can say is that I've been covered by our Judge President, so I don't have anything further to ask.
Thank you, Premier. Any questions for the candidate commissioners? But the sound people must please assist us. There's something wrong with that connection. Commissioner Lekhanyan?
CJ, good morning.
No,
Good morning,
and
CJ.
this sound issue has prevailed since we started here. Why is it not being solved?
Must I proceed?
Yeah, let's try.
Okay. Good morning, JP.
Good morning, Commissioner.
Good morning, Matabel.
Good morning. Good morning, Commissioner.
CJ, my question is going to be very short. It's with regard to mediation, since the candidate has completed a course on arbitration. I wanted to check, given the predominance of traditional leadership disputes in our province, do you think that mediation is an option? And if it is an option, what do you think will be the benefits towards the stability of our rural communities and enhancing the chances of sustainable development?
Commissioner, I think mediation, it will benefit us. In the first place,
Just bring the mic closer to you, please. We can't hear you.
Yes, mediation is a very important part of dispute resolution. Even in our courts, we have section 41A that deals with mediation. But I think it's very, very important that issues like this one, where that dispute about traditional leadership, if there can be more mediation can be involved, it can resolve many problems, because sometimes coming to court itself, it doesn't solve the problems. We get a judgment, we get an order, we go back, because there was no proper engagement between the parties. Most of the time, parties go back to their own positions again, and the dispute starts again. So I think mediation, it will play a very, very important part in dispute resolution insofar as the traditional leadership dispute are concerned.
All right.
Yeah, no, Matabel, I think your details are very skimpy. I want to know what will be the benefits for a province like ours. I agree with you that mediation can be an option. You answered that question in affirmative.
Yeah,
Yes. Okay, let me say it this way.
yeah,
Traditional leadership disputes have divided our communities, you know.
yeah.
So what will be the benefits if we follow mediation as an option?
Yes. Like I say, the mediation helps because we have a third party involved, a neutral party involved that assists the parties to resolve that dispute. So the benefit is you've got somebody in between you who assists you, and it gives the parties of both sides to ventilate their positions to the mediator, so that the dispute is resolved in the sense of each party having contributed his version. So, like I say, if we rely only on court decisions, without the parties having had the opportunity to say their version to an independent party, it may not assist as much as we've got a third party assisting the parties to resolve that dispute.
Okay, thank you. Commissioner,
Chair,
is the follow-up?
CJ, a follow-up.
All right.
Thank you. Good morning, CJ. Good morning, commissioners. Good morning, council.
Good morning, Commissioner.
A follow-up from what my colleague said. There is an objection, one of the objections, of course, but the others will be taken by my other colleagues.
Yeah.
But what is incidental to what my colleague is saying is an objection by Joan Jacobs of Ube and May attorneys.
Yes.
As regards the matter which they allege you delivered a judgment on the 6th of September this year.
Yes.
And amongst other things, they say you then made a pronouncement that would not have that the superior courts have no discretion and jurisdiction to interfere with the judgment of a traditional court.
Yeah.
My question is, was this brought to your attention, this objection?
Yeah.
And if so, what is your response to that objection? Or what was your response to that objection?
Yes, I responded to the objection, and I said it's not correct that I said the High Court should not be involved in this. What my problem was that when they approached a High Court, they wanted a declaration to declare the judgment from the traditional court a nullity. And I said, no, it can't be in that way. Even if you think that the traditional court has no jurisdiction, and you think the High Court has jurisdiction, the way to do that is to take a review and not to declare the whole judgment of the traditional as a nullity, because that was my problem. And that's how I responded to the query, to the complaint.
Thank you, CJ.
Thank you, Commissioner Nkonyane. Was your hand up, Prof? Go ahead.
Thank you very much, CJ. Good morning, Advocate.
Good morning, Mr. Commissioner.
You know, I'm interested in establishing whether the judges or the would-be judges that are interested to be appointed, they are familiar with tried principles, because when one reads judgments of late, it seems to me that some of the principles that one thought were tried are not actually gotten right.
Yeah.
So this question is based on that on that premise.
Yeah.
Let's say a party before you wishes to apply for condonation.
Yes.
And you have to consider that application.
Yes.
What is not necessarily the test, because the test will be the interest of justice, but how has the courts developed the criteria that needs to be complied with for the court to be able to consider whether or not to grant the condonation? In other words, what would the person before you have to do to convince you that it is in the best interest of justice to condone whatever it is that they want to be condoned?
Okay, yeah, well, the best interests is the overall assessment at the end. But what the party needs to satisfy a judge is the reason for non-compliance. Why did not comply? Secondly, and how long did you take not to comply with it? So if you explain to the judge that I was aware of whatever court order or the date, but I did not comply because of this, and the court wants you to tell in each and every, tell the reason why, the date, why did not do this and this, you must explain fully why you did not comply with that. And then the other thing that you must convince the court is that there are prospects of success in the main. So they're not giving you a condonation just for that, and then you don't have prospect on the main. So you must convince the judge that you've got a reason not to comply, but on prospect as well. You've got prospect of success in the merits in the main.
And the issue of prejudice as well.
And the
Thank
issue of
you very
prejudice
much,
as well.
CJ.
Thank you. Commissioner Nkaito?
Advocate Ledwaba, I just want to get some clarity because there's something I don't follow with this settlement and the letters from the LPC.
Yes.
You are a member of both Limpopo and Gauteng.
Yes.
And why don't you have a letter of support from the Limpopo Legal Practice Council?
Well, I didn't ask for it, but I don't know why they didn't. They are aware that I'm a member here, but I don't know why they didn't support. I didn't ask them.
No, but I would have thought that if you are a member of two societies, you would ask for a letter from both.
No, I didn't ask them. No, I didn't. I didn't approach them for a letter. I didn't approach any of them.
Well, that's what I don't understand. You have to ask for a letter of good standing from your professional bodies.
Oh, okay. Letter of good standing. Okay, I thought the Legal Practice Council covers both of them.
No, the one you have is from Gauteng. It doesn't cover Limpopo.
Well, there is a confusion because when I moved to Limpopo, I didn't deregister myself from Gauteng. And when I asked this letter, I went to Polokwane, and Polokwane said, no, we're still registered in Gauteng. So you must go and get a letter from the Gauteng. So I went to Gauteng and got the letter. So I'm a member of Polokwane, but I'm still registered in Gauteng. Even the GCB, my GCB, I deducted from Tshwane. It's not deducted from Polokwane.
And there are also no letters from the societies themselves.
Yes,
Neither Limpopo nor Pretoria Society.
Yes, I thought that's what we asked before. That's why I said I didn't ask them.
Yes, well, even the law society, I mean, the legal practice, there's only one. Then when I look at this, the issue that I took with you last time
Yes.
was that you were accused of duplicating invoices.
Yes.
Now, when I look at the settlement you have attached, Annex IE, it has nothing to do with duplicating invoices.
Yeah. Okay. Let me put in this. Why there was the talk about duplication was just like this. When I submitted an account, there were issues that we discussed with them and say, okay, you can't take this one, and they took them out. And when I submitted, and they said to me, I must submit a new statement. I submitted a statement. And then that statement, the figure went up. And then the complaint was late to the council, and we were called by the investigating committee. And the investigating committee said to us, what is the issue? And I said, we differ about the figures. Because after taking the figure out, we differ about the figures. And they say, do you think you'll be able to resolve this in 30 days? And he went back, we sat down, we agreed on the figure. And that figure, after we paid that figure, so only after they paid me figure, they wrote an agreement to say, we settled that figure, that matter. And that's why this matter is proceeding, the matter that we were in dispute with, after the money has been paid.
And there's no letter here from the LPC saying that
the dispute or the complaint of duplicating invoices has been withdrawn.
No, there's no letter, but what I can tell you is that
Do you agree with that or not?
I agree with that.
Yes.
But what I can, in response to that is that after we went in April, investigation committee, then the complainant showed a letter that he gave to the council to withdraw. Then when I went in June, they gave me this letter of good standing. So that gave me comfort that there's nothing outstanding. There's no complaint that's there with the council.
No, the complaint, you see, this is the problem, Advocate Ledwaba, I'm terribly sorry. If you're an advocate and there is a complaint of duplicating invoices against you,
Yes.
it doesn't matter that the complainant wishes to withdraw it, whereas I don't even see any withdrawal by the complainant of that. Because it is still up to the LPC as the custodian of good morals
Yes.
to decide whether to continue the charge against you.
Yes.
There is nothing here that shows that they have decided not to continue with the charge. There is no response from the so-called complainant that the duplication of invoices charge has been withdrawn. You've submitted a settlement agreement which seems to be about the fees that you will charge in the future, which for me really looks like there's something wrong here that you are doing.
Okay. Maybe let me get to that letter. I didn't get to that letter. What page is that letter?
The settlement agreement is page 132
132 of the...
of your application.
Yes.
Attached to your covering letter, nomination, acceptance, it's Annexure E.
Yeah, let me just see where the... Number eight says that the complainant undertake to withdraw the complaint at the
Yes,
LPC.
I know.
Yes.
I don't have anything that says the complaint was withdrawn of duplicating invoices, and I don't have anything from the LPC that says the complaint against you is no longer being pursued.
Well, Commissioner, if you're not happy with the letter of good standing that was given to me in June, after this letter, well, I don't think I can take it any further. I was comforted with that letter, that good standing. That's why I asked it in June. So if the letter says to me in June that there's nothing outstanding against me, and maybe you're saying to me after June they can come back and say there's a complaint which has been withdrawn, I can't take it any further.
Well, I don't have anything from Limpopo, I don't have anything from the societies, and I don't have anything about what happened to the duplication of invoices. So I just don't understand.
Yeah.
Sorry, can I make a follow-up, Chief Justice, just on this thing of good standing? I just want to make a correction, and correct me if you know otherwise. A certificate of good standing does not mean that there's no complaint against you. All what it simply means is that we have paid the dues and you are allowed to practice. It doesn't relate to complaint.
Well,
In fact, what I'm saying, that is the purpose of the letter of good standing.
Well, if I understand that letter, if you can look at that letter, it says there's nothing, there's no complaint. Can we look at the letter of good standing, letter from the Law Society, from the LPC? What page is it?
Sorry, I'm saying to you.
Yes.
This is what
Oh,
I'm saying.
okay.
I'm saying as a matter of fact,
Yes,
the certificate of good standing
yes.
does not mean that there's no complaint against you.
Oh.
It simply means you are in good standing with your subscriptions, that is payment of membership fees and all that.
Okay.
Yeah, so your answer is incorrect to Commissioner Ngcukaitobi to say, no, because I have a certificate, therefore that complaint I treat it as if it is not there.
Yeah, well, I don't know. If the commission is not satisfied that the complainant has said to me, I'm going to withdraw this complaint, and then she gave me a letter that's sent to the LPC to say that I've withdrawn it. If the commission is not satisfied with that, I can't take it any further.
Commissioner Pillay?
Thank you, CJ. Good morning, Advocate Ledwaba.
Good morning, Commissioner.
Perhaps I can ask you to open up the letter from the LPC. It's at page 81 of the bundle.
81.
Now, part of the difficulty.
Sorry, is it
Page 81.
81 of which panel now? I think,
Your bundle, the bundle that's got your application in it.
this one.
Is something else.
I've got it.
Or you're reading your screen.
This is 31. 31. Is this 31? I'm sorry, it's 30, it's 31. My 3 looks like an 8. It's 31. It really does look like an 8.
It does.
Do you have it, Advocate Ledwaba?
Yes, I have that, yeah.
Now, the first difficulty is that this certificate comes from the Gauteng LPC.
Yes. And what's the difficulty about that?
So obviously, we don't know what's pending before the Limpopo LPC.
No, as I've explained that I'm not a registered member in Limpopo as we stand now. That's why I got the letter from the Gauteng. When I went to them, to Limpopo, to say, give me a letter of standing, they say, no, you're not registered as a member, so go back to Gauteng.
All right. Then
Yes.
can I ask you to go to paragraph 3 of that letter?
Number 3, okay.
And I think that's what you rely on. But it's quite a specific paragraph. It says that it certifies that your name has not been removed from the roll and that you have not been suspended. And there are at this date no proceedings pending by the council to strike your name from the roll or to suspend you.
Yes.
So it's dealing with very serious, extreme ends of misconduct, which could result in a striking or in a suspension, but not dealing with what we would understand to be misconduct in the ordinary course. So there's no indication in this letter that an ordinary misconduct proceeding is not pending against you.
Yeah, well, yes, if you put it in that way, that I understand. Yes. Like I say, if the commission not satisfied with the letter, with the agreement, and that she showed me a letter that gave to the council to say I'm withdrawing it. If she's not satisfied about that, I can't take it any further. That's what I took that as being a conclusion to say the council will not be able to proceed in a situation. A complainant said, we have settled our dispute, and I withdraw it. And this is a letter that I'm withdrawing.
You see, Advocate Ledwaba, the difficulty I have with your explanation is that the contents of the letter are plain. You just have to read the letter to understand what it certifies and what it confirms.
Yes.
And it certainly doesn't confirm that there is absolutely nothing pending against you as you are sitting here today.
But if you say, if they say, I undertake to withdraw a complaint, the only complaint I had with them related to that statement. But if that doesn't satisfy you, I can't take it any further.
Because you've got no confirmation that the complaint actually was withdrawn. We've got the undertaking that it will be withdrawn, but no confirmation that in fact it was withdrawn.
I said when I explained, I said, I went to her, and she showed me a letter that she sent to the council to say, I am withdrawing this complaint. I did not know that it would be an issue, and then I would have brought that letter. But if you say to me, she has made an undertaking to you, she has given LPC a letter withdrawing that a complaint, and you say, still the LPC has a discretion to proceed, I can't take it any further. I was satisfied with that explanation.
CJ, may I do a follow-up on that?
Yes.
Yes. Good morning, Advocate Ledwaba.
Good morning.
The letter, I think the difficulty that we're struggling with is the settlement document that you have attached.
Yes.
It speaks to the future,
Yes.
how you would be charging for services to be rendered. So it doesn't tell us anything about the dispute, past dispute, and how it was settled. It doesn't tell us anything about that. Now, so that's the first thing. And so on the face of it, it looks like you have attached the wrong document when you speak about, because in the body of your application, you say, I attach a settlement agreement. And when one looks at this, it doesn't speak to to the complaint as resolving the complaint, the terms of the resolution. So that's the one struggle that there is. And then you keep referring to this letter. From your last interaction with Commissioner Pillay, I take it you haven't sent that letter to the JSC?
No.
You haven't?
No, no.
Are you able to do that?
The letter from...
If you are required, if you were given the
Yes.
opportunity to present it,
Yes.
would you?
If I was, okay, let me answer in this way. Because this complaint had resulted in the main matter that we're supposed to do not proceed because of fees. And then we then resolved everything, even that comes, to say, even in future about this matter, let's agree how we're going to conduct this matter, because we don't want to come back and got problems. And then we agreed only even if the fees in relation to this matter, so that this matter proceeds without problem. Because remember, this register was taken over. It's taken over from another registrar. And she was coming to say, I'm not happy with what you were doing with the previous registrar. So going forward with this matter, let's resolve everything. So we covered everything. You can see that we covered even the traveling allowance and everything. So it was dealing with that matter so that that matter will proceed. As we speak now, we have agreed to set the matter down. But the letter, if you say to me, given an opportunity to get a letter from the complainant herself, in which she sent a withdrawal, I can get that letter from you, because she gave me that letter. I had letter. I didn't know that it was community issue.
Yes.
I can get that letter and present it. That letter I have.
Yes, it's really not just about the complaint having been withdrawn. As we understand, I understand it.
Yeah.
The complaint was you were overreaching. You were double invoices. That was the complaint. So when you say the matter has been settled, one expects clear terms of, well, it's accepted that you were not double billing. That's what the settlement would entail. Alternatively, you were double billing and you have paid back. One expects to see that when you say the matter has become settled. It's not good enough to simply say the complaint was withdrawn, because our interest is not just whether there's a complaint pending. It is also, was there merit to the complaint against you of double billing or double invoicing, and how was that finally resolved? And right now we don't have any of that.
Okay, I can explain that one. Let me give back the background of this situation. I had presented the bill, and in that bill, there were items that we agreed should not be there, and then we removed those items. And then they said to me, for their internal process, I'll need to submit a new statement. Then I submitted a statement. When I look at the statement, the figures then was more than that the figure that was there. And then I sat with the legal officer, and I said, this is a problem, because the figure now is more than the figures there. And even when he made the figure, and we'll remember the history, when he made the figure became even more. And we couldn't agree. And that's where the problem that came and said, well, we can't agree with the figure. But when we went to the investigating committee, the investigating committee said, can you settle this matter? Because it's only about the figures that you differ. That's why they went back. And then the complainant drew up this agreement. And then on the previous account, I did not have to submit another account, because another account was now causing confusion, because then I had submitted less money. So they used that statement that gave them to them, and they just deducted what was agreed upon, and then we read that figure. That figure is less than the figure that they given them later when I conducted the statement, and the statement that was given by the legal person, I mean the manager himself. So we had a situation where I submitted a statement, and that statement was less than what I was supposed to be paid. And because we had a figure to say, if we deduct these items, the figure should be less than this figure. And when I did the next statement, it was more than that statement. And even from the council, it was more than that. So there was a figure that was more than that was expected. But when we settled, when we came back from the investigative committee, the complainant went to the original statement and just deducted that we agreed upon, and then that was paid. So that agreement was written by the complainant herself, and it was covering all the issues, including going forward, because she was new, it was a register that was new, that she wanted new arrangements to be done. So that explains that. So this agreement, this was not written by me, but I accepted it. When I said, how much are you going to pay me? They said, we're going to pay you, we're not going to use new statements because now it's more than the figures. We're going to use the old statement, just deduct the money and pay you, and then accepted that.
Thank you. Thank you, CJ.
Commissioner Matolo Dlebo?
Thank you, CJ. Advocate Ledwaba, what I just wanted clarity, the fee issue, was it done by the fee assessment of the LPC?
No, I had requested, when this started, I had requested that this be done by the fee committee. And the LPC decided, no, it's not yet a charge. You have not been charged. It must go to the investigating committee first. And this is the investigating committee that look at these three statements. The statement that I submitted with the deductions, the statement that I made, which was more than the statement that I submitted, the statement that was done by the legal manager of the council. This way were higher than the figures. And they said, but can you settle this matter? I said, I'm going to settle this, but I can settle it. So I accepted the figure that was less than the figure that I arrived at after making the recalculation, giving a new statement. Even the figure that the council itself, it was 408 or something like that. And then we went back to that figure where I had made wrong calculation that was against me. And then I accepted that.
Thank you. At least I'm clear that it went to the investigating committee. Then
Yes.
they advised you to, there was a discussion.
Yes.
Then that's what they advised you. But I just wanted to bring clarity to this issue of good standing.
Yes.
The LPC will never issue two letters. You either get a registered, if you are registered in Gauteng and Limpopo,
Yeah.
but they take the place where your registered office is. They want Limpopo and Gauteng won't give two letters. It's only one where you have registered. Thanks.
Yeah.
So you practice in both provinces, though?
Yes, as I speak now, I haven't deregistered myself from Pretoria. I'm still a member in Pretoria, but I don't have an office there in Pretoria. I'm in Limpopo. So like I say, my GCB money are still deducted by Pretoria. So when I went to Limpopo and said, can you give me a good standing? He said, no, you're not registered members here. You must go back to Gauteng. And I went to Gauteng. Indeed, Gauteng, I found out I was still a member. Then they gave me this letter.
All right. Commissioner Mangena, is yours a follow-up question?
In relation to this letter of good.
Okay.
Yeah.
Then ask the question so that you can settle this once
good.
and for all.
Can I proceed, CJ?
Yes.
Yeah, okay. Good morning, Advocate Ledwaba.
Good morning, Commissioner.
Just clear this cobwebs for me.
Yeah.
When your complaint
Yeah.
was registered with the LPC, you
Yeah.
were notified that a complaint has been lodged against you.
Yes.
And subsequent to your engagement with the investigating officer,
Yes.
you were offered an opportunity to address whatever issues with the complainant.
Yes.
And since then, you have not had anything from the LPC.
I haven't had anything from LPC.
Because my understanding is, if a complaint is withdrawn against you as a practitioner,
Yes.
the LPC, in as much as they notified you about the complaint, when it's withdrawn,
Yes.
they are obliged to write you a letter and advise you that the complaint has been withdrawn.
I'm not sure. I'm not sure there's an obligation on them. But if they received a letter withdrawal in May, and I haven't had anything from them. I thought that is the end of the matter. I accepted that is the end of the matter, because if they receive that letter, which I undertake to give to them, to the commission, and if in June then they gave me letter of intent, then it's understanding, and that complaint was still at investigation level. It was not at it not reached a decision where they said there is a misconduct against you. It was just a complaint. It was at investigations level. So if I haven't received any letter from them, I don't know if they, at the investigation level, they give you a letter to say this matter is not proceeding or not, or they give you a letter only after you have been charged for misconduct. Because as we stand now, I've never been charged for misconduct. It was still at investigation level. That's why the committee itself said, having listened to what you say, this is dispute that you can resolve, because it's a fee dispute. And I understand why Commissioner Glepu say, because it was a fee dispute, was it with committee? And in my letter that I wrote to the council, I said, if the commissioners can have a look at that letter, I said to them, in my view, this is a matter that can be dealt with by the fee committee. And they said to me, the fee committee comes in only after you have been charged. Because you have not been charged, it's still at investigation level. It's done by investigation committee.
Yes, and that is how it should be, because a complaint does not necessarily translate into a misconduct.
Yes.
It becomes a misconduct once the council, through its officials, have
Yes.
established all elements necessary for it to constitute a misconduct.
Yes.
But here's the issue for me.
Yes.
This complaint, in which LPC was it registered?
Yes.
Was it in Gauteng LPC or Limpopo?
It was in Gauteng, and even when I received that complaint, I asked them if the commissioners look at the documents, they've got documents that, and I said, but why am I charged in Gauteng because I'm in Limpopo? They said, no, we decided to charge you in Gauteng. I didn't have a problem with that. So it was in Gauteng, I was charged in Gauteng, even though at that point I was in Polokwane.
Thank you, Advocate. Thank you, Chief Justice.
Commissioner Trollip?
Thank you, Chief Justice. I don't want to flog a dead horse, but I do want clarity, because there's some ambiguity about the answers to questions. When Commissioner Ngukai Tobi asked Advocate Ledwaba, do you practice in both provinces? He said yes.
Yeah.
He said, are you a member of both LPCs? He said yes. And he said, there's only one letter from the Gauteng LPC. Why isn't there a letter from Limpopo? He then said he didn't ask for a letter. And then Commissioner Ngukai Tobi said, and there are no letters from the societies. And he confirmed that he didn't ask the societies for any letters. But then he said, when I asked for a letter from Limpopo, they said I must get a letter of good standing from Gauteng because I'm not a member of Limpopo. Now that confuses me, because even the answer to Commissioner Mangena now, he's just said, he asked why were they charging him in Gauteng and while he was working in Limpopo, and they said because this issue arose in Gauteng. Now, I need clarity. Is he a member of the LPC of both Gauteng and Limpopo, yes or no?
Well, the LPC is here, and that's what Commissioner Matolo Dlepu, I thought, explained earlier, but she can do that again.
Well, the LPC is one,
Yes.
but we've got provincial offices. So my movement from Gauteng to Limpopo, I did not resign as a member of Pretoria Bar. So I remain a member of a Pretoria Bar. And I joined Polokwane. So I remain a member of two bars. But LPC is one. I think the question is, why do I get one letter from the province of Gauteng, not province of Gauteng? I said, I went to Gauteng province for a letter of good standing. They said, you're not a registered member here. You're still registered in Gauteng. That's why I went to Gauteng. about the request that Commissioner asked, I thought she was asking if I've approached my societies about the letters, and I said, no, I did not approach the societies, not the LPC. Both Polokwane and Gauteng, I did not ask them. That I was responding to that.
Chief Justice, I'm no clearer with that response. I am no clearer.
I think for present purposes, we can let the matter end here. Then we can debate any lingering questions during deliberations. Fortunately, we have the experts in this area.
Chief Justice, just one point. I think for the record, we must say that it is important to get a letter of good standing from your bar as well as from the LPC, because there might be a letter of complaint against you at the bar that is not at the LPC.
I'm sorry?
Most advocates give us letters of good standing both from the bar and from the LPC. And I think there is a good reason for that.
Well, is that a question?
No, it's a comment for the record that I think it's important for candidates to. The LPC is the statutory body, but the bars are there for a reason. And often complaints are lodged with the bar that don't get to the LPC, and we need to know about them.
Chief Justice?
Commissioner Pillay first.
Thank you, Chief Justice. Advocate Ledwaba, may I ask you about the matter of Shabalala versus Maluleke and others?
Chief Justice, I apologize. I wanted to follow up on this issue before a new issue.
No, I thought hers was a follow-up. I learned only now that it's not.
Yes.
Ask your follow-up.
No, thank you very much, Chief Justice. I think we need to clarify something. LPC is the sole regulator of all the legal practitioners in South Africa, and that is a fact. The voluntary associations, they are exactly that. It might be recommended that if you are associated either to the GCB, PABASA, or LSSA, or any of those are voluntary associations. If you do get anything from them, then that's fine. Perhaps it can be recommended. But I don't think it is proper to say, as a matter of course, for these proceedings, we need to get letters of good standing from those things. I don't think that is proper. Thank you very much, CJ.
Well, as I said earlier, I think that's something we can debate later during deliberations and our own housekeeping sessions. Not as far as it's concerned for the candidate, he's given his best answers and he can't take the matter any further with them.
I accept that.
Thank you.
Sorry, Chief Justice, but when a statement of law is made which is incorrect, I don't think the JSC can responsibly leave it. There is a judgment of the SCA by Judge Ponan in the entire matter that says the bar is the custodian of good morals of advocates. So that's the point that Commissioner Steinberg is making.
And my only point is that for purposes of this what is happening here now with that candidate, I think we may have exhausted the topic. This other discussion we can have among ourselves later. Or do you disagree with me?
I accept that, CJ, but I think the position is wrong nonetheless, that Advocate Ledwaba is addressing. Thank you.
Thank you. Minister?
Thank you very much, Chief Justice. Good morning, Commissioners, and good morning, Advocate Ledwaba. How are you?
Good morning, I'm okay. I'm okay, Minister.
Okay. I'm okay. I want to focus on the Amalgamated Lawyers Association complaint.
Yes.
I'm sure you are aware of it.
Yes, I'm aware of it. Yes.
Firstly, I just want to know, they say you failed or refused or neglected to allocate a hearing date beyond their request.
With respect, Chief Justice? Chief Justice?
Yes.
With the greatest respect, in relation to the question put in relation to this matter. Perhaps I thought it is important to alert the honorable commissioners and the commissioner minister that the dispute or the complaint raised by Amalgamated Lawyers Association against the candidate is a matter is a subject of appeal pending in Thohoyandou local division. The date is set for the 6th of December 2024 to be heard by the full court in that local division. So I just thought I needed to alert the minister that the matter is sub judice, arising from the same complaint and the proceedings.
All right. Thank you. Thank you, JP.
I can let it pass on that note. I think it will help.
Thank you.
Thank you, Minister. Commissioner Moimang?
Thank you, CJ. Good morning to yourself and commissioners. Good morning, Advocate.
Good morning, Commissioner.
Just one from myself about the comment made by GCB. In as much as they acknowledge your experience, their view is that your appointment would not further the diversity of the bench.
Yes.
So I just want to get a sense from yourself, what is your view in relation to that statement? Thank you.
Well, yes, that question was raised last year, but this year, in May, I had a discussion with the Deputy Judge President, and she asked me if I'm going to make myself available this year. I said yes. If nominated, I say yes. And she said to me, in any event, that issue of a female judge in Thohoyandou local division has been resolved, because she said to me, she's permanently based there in Thohoyandou. And I haven't seen her in Polokwane from term starting after March. So I thought, from what she said to me, because she's now there in Thohoyandou, we've got her as a woman, we've got 2 judges. That has been addressed. But that doesn't mean that if I had not had a discussion with her, and I was asked to make myself available, I'll not make available. But I'm just saying that question, from what she told me, that has been resolved.
Thank you, Advocate Ledwaba. Thank you, CJ.
Thank you, Commissioner. Another one? Okay. Is there follow-up? Okay. JP Mlambo.
Good morning, Advocate Ledwaba.
Good morning, Commissioner.
Just to confirm this, you say you've done something like more than 68 weeks acting.
Yes.
And in that time, you've done predominantly civil work.
Yes.
Right.
Yes.
Have you ever heard of the plus connivence rule, and in what circumstances is it applied?
Well, yes, plus connivence rule it's a rule that used in disputed litigations. The background is this: as a litigant, when you approach the court on motion, you decide whether you decide whether you want to go for trial or you want to go for application. And trials that where evidence are given. Now, that rule works in this way. If you are a litigant and you decide that you want to follow the application route, well knowing that potentially there can be dispute of facts, you denying parties an opportunity to be tested on evidence. And the rule is this: once you have decided to make that decision, and evidence are given, and there's a conflict, there's a dispute, you must accept that the evidence that's come from the defendant will not be rejected unless it's so far-fetched that it can be rejected on papers. So because you did not give, you chose a route that denies the defendant an opportunity to be tested, you cannot complain if his evidence is accepted, unless it's so far-fetched that it should be decided, it should be rejected on paper. That's how I can summarize it.
Okay. One last question, CJ. In your questionnaire, am I correct that you list, is it 2 or 1 of your judgments that were upset by the SCA? All the others were upheld.
Yeah, it's only one, the Mukhuba judgment that was upset by the SCA.
Thank you very much, CJ.
Commissioner Pillay?
Thank you, CJ. Advocate Ledwaba, the minister had asked you about the complaint from ALA.
Yes.
And I think the indication from the JP was that there's a matter pending before a full court that deals with some aspect of the complaint.
Yes.
Is that matter the Shabalala matter?
You're asking me about that matter that's in there?
Yes.
No, I'm not aware of that matter, December. That's the judge president's talking about it.
Yeah, but you dealt with the Shabalala matter at some point.
Yes.
In relation to an allocation of that matter on the urgent role.
No, I was never approached to allocate the date. I think what the judge president was saying that matter as a whole, if I understood him correctly, it's before the full court.
Yes. I just want to deal with the question of allocating that matter. It had come to you when you were in the urgent court, and you wanted to allocate it as a special motion.
No. I didn't do that. What happened was that after I decided that the council could not appear. That litigant was left without a legal representative. So we had to give an opportunity. And there was a suggestion from one council to say, can we approach a court for special allocation? I said, and it's on record, and I said, that is done by the judge president. It's not done by me sitting in a sitting court. So the directive says if you want a special allocation as parties, you must direct letters to the office of the judge president to be allocated that. So we're dealing with that. But at that point, in that matter, we got a date from the registrar. That matter was allocated again on urgent basis to a date. And I'd left by then. I'd left Toyando then.
But you'll know that the issue raised by ALA relates to the information you had imparted to the parties. You said to them that Judges Patudi, not the JP, the other AM Patudi, and Judge Chidada had indicated that they were conflicted and therefore not available to preside over the matter.
Yes, the issue was this. It's Judge Patudi, who was the senior judge, who indicated to me that both of them are conflicted.
Yes.
That's
Now
the first answer.
Okay, you know that Judge Patudi has issued a formal ruling dealing with the matter.
After I've left, yes.
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 And in his formal ruling, he indicates that that exchange never happened, that exchange between you and him.
No. Okay, let's deal it. There are two issues there. The first issue is that when he gave me the file, we had a discussion. But then when we were talking about allocation of judges, and I indicate to them, the allocation as far as I remember, the allocation for special dates are done by the JP. But I don't know if the senior judge sitting here can do that. Then we adjourned. When we adjourned, I looked at the directive confirmed that only the judge president could do that. So I did not go to him and say to him, do you have authority to allocate the special trial? Because special trial, then I confirmed from the directive that that was done by the JP. So what I did, I postponed this matter to still a agent court. It was for the parties, if they wanted to get this matter to special allocation, to approach the Judge President's office by way of writing.
So
That's
when
what I
Judge,
explained.
so when Judge Patudi records in his ruling, and I'm just going to read to you what he records in his ruling, right? He says, at this stage, I find it apposite to indicate that on the said date, Ledwaba AJ did not present himself to me in chambers as the senior judge regarding this matter, or at all.
Yes.
It is accordingly a patent error, as placed on record, that Ledwaba AJ approached me in chambers, ostensibly seeking advice on whether or not to postpone the matter. So you agree with that?
I agree with him that I never approached him for special allocation. That I agree with him. Because the directive, as I said, when I checked, the directive does not give a senior judge authority to give a special allocation. So I did not go to him, he's right.
But when you reported to the parties that Judges Patudi and Chidada had indicated that they were conflicted, not that they were not available, that they were conflicted in this matter, where did you get that information from?
Okay, let's deal with one part. Let's park this thing of saying, if we agree that the recording that are set to the parties, I think the person who give the special allocation is only JP. I'll check with the senior judge if here in division can do that. Then I checked and I found that okay, he can't do that, and then we went to the registrar. But there are two instances where the Patudi talks about. The first time, when this matter was allocated to me, it was allocated to him in his chambers. He gave to me this matter in his chambers. I went with him. I only went to his chambers once. Then I did not go to him, to his chambers again. He's right, for special allocation.
Advocate Ledwaba, my question is, when you said to the parties, when you recorded that both judges had indicated that they were conflicted, where did you get that? Where did you get that information from? No.
I said on the record. I confirmed on the record that Judge Chidada was involved in this matter. There's a ruling that was made. That came from our meeting with Judge Patudi when he said to them, they were both conflicted. But there's nothing in the files that says to me Judge Patudi himself may have been conflicted. So it comes from the record that yes, Judge was involved in this matter at one point where he made either a ruling or a judgment. I don't know. I can't recall now. But that is it. So Judge Chidada, I never had a meeting with Judge Chidada. No.
You see, Advocate Ledwaba, there's a transcript of what you said.
Yes.
And I'm going to read the first two lines of the transcript.
Yes.
The transcript is only one of them, so they indicated to me that both of them are conflicted. I think they indistinct about this matter, so I'm going to adjust this matter to the 16th of April.
Yes.
So those are the words you said, that both of them are conflicted. You put it on the record.
Both of them are conflicted? No, I never
You said only one of them, so they indicated
Yes.
to me, that both of them, they are conflicted.
No. Yes, that I hear what you say, but I never met with Chidada to say, to confirm from him that he was conflicted. I got it from the record.
But let me just take it slowly, Advocate Ledwaba. Do you accept that you made these utterances?
To say both of them told me. No, I never said.
No, you said, so they indicated to me that both of them, they are conflicted.
Yeah, no. If that is that will be incorrect because I never met Chidada in this matter, then even now. I met Judge Patudi, but from the record, Judge Chidada was involved in this matter. So for me, I confirm that he was conflicted. Yes.
Chief Justice, sorry, Advocate Ledwaba.
Yeah.
Did Judge A.M.L. Patudi tell you that he was conflicted or not?
He told me that he was conflicted. He told me in his chamber, he said himself, we were three. Yes. And I was I was on criminal matter. I was doing criminal matters. When he called me in the office, he said, text is fine because both myself and Chitata were conflicted in this matter.
Yes, so when on the 16th of April 2024, he said, in a judgment,
Yes.
it is manifestly and wholly untrue and incorrect that I had any conflict of interest in the matter. He was lying.
Well, I don't know. It's a senior to me. I won't say he was lying or not. But I can only tell you about what he told me in chambers. But whether he's lying or not, I won't be able to say that.
Can I just follow up, Chief Justice?
Yeah, before you, before you do that, Commissioner Pillay, you say, what does the fact that he's senior to you have anything to do with anything?
Yeah, well,
You were asked if he lied in that judgment, and then in your answer you include that he's senior to you, and that just confuses me. Why is that relevant?
Yeah, it's relevant to me because in my response, I said we were sitting there, we were three of us. So he was the senior judge of all of us. So when he called me, he said to me, I'm allocating this matter. He was allocating this matter to him as a senior judge in that division. And it's explained to me that himself and Chitata were conflicted in that matter. So it's in that context that I said I was given a matter by a senior judge who explained to me he's conflicted together with his judge.
Commissioner Pillay?
Thank you, Chief Justice. Advocate Ledwaba, I want to give you the benefit of my concerns so that I could get your response to it.
Yeah.
Just a few minutes ago, I put to you exactly what Judge Patudi said in his ruling, his formal ruling.
Yeah.
And I asked you, do you confirm that it's correct? And your answer was that you confirm that it's correct.
Well, maybe just remind me the rule, but if the ruling says, I never went to his chambers where I got the file, no, that will not be correct. Because I got the file from his chamber.
Then I must ask Advocate Ledwaba, why did you confirm it when I put it to you just now? Because he says that Ledwaba AJ did not present himself to me in chambers as the senior judge regarding this matter or at all. And I put that to you and you confirmed that he's correct.
Commissioner, let's distinguish two instances. The first instance is when I received this file. I went to his chambers because he called me. The second instance is talking about when I indicate to the parties that I will inquire from the senior judge if he has authority to allocate special trials. And he's right when he says, I did not come to his chambers. Because when I look at the directives, I confirm that only the JP can allocate special trials. And those special trials are allocated on the basis of parties applying to the JP. So there was no need, even if I indicate to the parties, I'll inquire from the senior judge, meaning Patudi. But I did not go there, because from the directive was clear that only JP allocates special trials. So it's right, I didn't go to his, but I went to his chambers when I received the file.
CJ, just one small follow-up from this. The JP is here. Mine is, the candidate is saying he was allocated a matter by a senior judge in the senior judge's chambers. JP, for the record, do judges allocate matters to themselves in Toyando, or how does the process work?
As far as my knowledge can stretch, matters are often allocated to judges by a senior judge.
Often, you said. Often, did you say often?
Yes, I said.
Not as a matter of course.
Well, I want to accept as a matter of course. It is a senior judge who would often allocate matters to a judge.
Yeah, else, Jay? Or was that all? Oh, all right. We've reached the end of your interview, Advocate Ledwaba. Is there anything you wish to raise with us before you leave?
No, there's nothing. Well, I can only check that if there's still a need for me to get a letter from the complainant to the LPC to say that she's withdrawing the matter, then I'll get that letter. But I'll get an indication if that's the need, then I can do that, I can get it from here.
All right. If we determine that it's necessary, the Secretariat will be in touch with you and let you know.
Okay, all right.
Thank you very much. You're excused.
Thank you.